Hello friends, today I am taking important questions and their answers on alternative dispute resolution. Question number 1. Enumerate the main object of Arbitration and Conciliation Act 1996. So the answer is the main objects of Arbitration and Conciliation Act 1996 are to provide a comprehensive, efficient and modern legal framework for resolving disputes through arbitration and conciliation, both domestically and internationally. The key objectives include main object of the Act. Number 1, comprehensive coverage of arbitration and conciliation. Second, minimizing court intervention. Third, fair, transparent and efficient procedure. Fourth, binding and enforceable awards. Promotion of conciliation and dispute resolution methods. Sixth is alignment with international standards. The Act aligns India's arbitration framework with the unilateral model law on international commercial arbitration and unilateral conciliation rules, facilitating smooth international commercial arbitrations. Jurisdictional clarity and reasoned awards. It mandates arbitral tribunals to provide reasoned awards and limits tribunals to act within the scope of their jurisdiction. Eighth is enforcement of a foreign award. The Act provides mechanism for recognizing and enforcing foreign arbitral awards under international conventions like the New York and Geneva Conventions. Question number 2. What are the grounds for challenge of an arbitrator? Can arbitral award be set aside? So the answer is grounds for challenge of an arbitrator with relevant sections under the Arbitration and Conciliation Act 1996 are as follows. Section 12(3) of the Act specifies the grounds on which an arbitrator can be challenged. A party may challenge an arbitrator if there are justifiable doubts about the arbitrator's independence or impartiality, or if the arbitrator does not possess the qualification agreed upon by the parties. Section 13 lays down the procedure to challenge an arbitrator. The challenging party must submit a written statement specifying the reasons for the challenge promptly after becoming aware of the grounds. Section 14 provides for the termination of the arbitrator's mandate if the arbitrator becomes unable or fails to act. This section also guides the appointment of a substitute arbitrator. Now, can arbitral award be set aside? Yes, an arbitral award can be set aside after judicial review. If the challenge under Section 13 is rejected, the party cannot immediately oppose the court. They must wait for the final award and then apply to set aside the award under Section 34 of the Act on the grounds of an improperly appointed arbitrator. Question number 3. What is the nationality and qualifications of arbitrators? Discuss validity of a tribunal constituted by even number of arbitrators. Mention relevant sections. The answer will be the nationality and qualification of arbitrators and the validity of tribunals constituted by an even number of arbitrators with relevant sections under the Arbitration and Conciliation Act 1996 are explained as follows. Nationality, Section 11(1) of the Arbitration and Conciliation Act 1996 explicitly states that a person of any nationality may be appointed as an arbitrator unless the parties agree otherwise. This provides freedom to the party to choose arbitrators irrespective of nationality, subject to agreements among the parties. Section 11(9) further empowers the Chief Justice of India or a designated authority to appoint an arbitrator of nationality other than the parties in international commercial arbitrations, where parties belong to different nationalities. Now, qualifications. The Act does not prescribe specific qualification for arbitrators by law, but parties can agree on qualification in the arbitration agreement. Institutional panels often include legal professionals like judges, advocates, chartered accountants, company secretary, engineers, and domain experts with experience and integrity. General norms require arbitrators to be impartial, free from conflicts of interest, of sound mind, conversant with the relevant laws, and capable of delivering enforceable awards. Now, validity of tribunal constituted by even number of arbitrators. What is the validity? A tribunal formed by an even number of arbitrators is generally not valid. Arbitration tribunals are typically composed of a sole arbitrator or an odd number of arbitrators, usually three, to avoid deadlock situations. If the tribunal has an even number of arbitrators, it can lead to a tie, paralyzing decision making. Hence, an even number tribunal is not favored unless there is a provision for a presiding arbitrator or a mechanism to break ties. Without such provisions, the validity of the tribunal may be challenged. The Arbitration and Conciliation Act 1996 does not explicitly forbid even-numbered tribunals, but the practical and judicial preference strongly favors odd numbers to uphold the principle of majority decision-making. Case law on even number of arbitrators in tribunal. Famous case in National Human Rights Commission versus State of Arunachal Pradesh 2016, the Supreme Court held that a tribunal or arbitral panel comprising of even number of members can lead to deadlocks which impair the tribunal's function and legitimacy. The court emphasized that a tribunal must be capable of delivering a decisive ruling through a majority which necessitates an odd number of arbitrators. Now question 4. What do you mean by award? Discuss form and contents of an award. So, an award in arbitration is the final decision made by the arbitral tribunal that resolves the dispute submitted to arbitration. Now, forms of award. It should be written. Section 31(3) of the Arbitration and Conciliation Act 1996 mandates that the arbitral award must be in writing. Signed. The award should be signed by the arbitrators with a majority member signing if there are multiple arbitrators. Reason. It should state the reasons for the decision unless the parties agree otherwise, or the award is made by consent. Section 31(3) and related provisions. Now, contents of award. The arbitral award must generally include names and addresses of the parties involved, the issue in dispute, the decision or ruling of the tribunal on the issues, the reason for the decision, unless waived, any applicable remedies, damages or directions, and the date and place where the award was made. Question 5. Discuss interim arbitral award and additional arbitral award with the relevant sections. Now, an interim arbitral award is a partial decision made by the arbitral tribunal on certain specific issues before the final award is rendered. Unlike interim orders, section 17, which preserve the status quo, interim awards decide substantive questions that require immediate attention. Section 31(6) of the Arbitration and Conciliation Act 1996 explicitly empowers the arbitral tribunal to make interim award during the arbitral proceedings on any matter that can be ultimately addressed in a final award. Now, characteristics. What is the characteristic of this interim arbitral award? Binding and enforceable like the final award unless parties agree otherwise. It may address issues such as admitted liability, interim payments, or specific claims that require resolution during the arbitral process. What is the purpose? To provide timely resolution of a salient issues, preventing delay or prejudice during litigation, ensuring efficient dispute management. An additional award. As specified in Section 31(4) and Section 31(7), an additional award is made by the arbitral tribunal after the initial final award, addressing claims presented during the arbitration but not included in the original award. It supplements and completes the initial award. It ensures comprehensive resolution of all issues within the scope of arbitration. It is usually issued upon request by a party or on the tribunal's initiative. Question 6. Discuss essentials of arbitration agreement and essential ingredients of arbitration agreement. Meaning of an arbitration agreement. An arbitration agreement is a contract between parties to submit present or future disputes to arbitration instead of court litigation. It forms the judicial basis for any arbitral tribunal. Essentials of arbitration agreement. It should be in written form. The agreement must be in writing as per Section 7(4) of the Arbitration and Conciliation Act 1996. This can include signed document, exchange of communication like letters, telegram, or any electronic means that provide a record of the agreement. Mutual consent and intention. Parties must voluntarily agree to resolve dispute through arbitration. Agreement to arbitrate dispute. The agreement must clearly refer to submission of disputes, present or future, to the arbitral tribunal. Capacity of party. The parties must be legally competent to enter into an arbitration agreement. Scope and subject matter. The agreement should define the kind of dispute covered, ensuring those disputes are arbitrable under law. Clarity and specificity. Specificity. The term including appointment of arbitrators, procedure to be followed, and the binding effect of award must be unambiguous. Signature and of parties. The agreement must be signed by parties, indicating their acceptance of the arbitration clause. Now, essential ingredients of arbitration agreement. Landmark case. There was a landmark case, K.K. Modi versus Ken Modi, 1998, and the following are the essential ingredients. The tribunal's decision must be binding on parties. Jurisdiction to decide dispute must derive from party consent or court order. The tribunal must impartially decide rights of parties. The arbitration agreement must be enforceable by law. Disputes to be referred must be clearly formulated before reference. Now question 7. Why UNICITRAL was adopted in India in the Arbitration and Conciliation Act 1996? The Arbitration and Conciliation Act is a comprehensive statute that modernizes dispute resolution in India by providing a unified legal framework aligned with international standards. The Act's main purpose are to provide an efficient, fair, binding, and internationally compatible framework for arbitration and conciliation, minimize court intervention, and promote alternative dispute resolution. These statutes modernize India's ADR landscape, reinforcing party autonomy, speedy resolution, and global arbitration integration. Its important provisions cover Arbitration Agreement Section 7, Appointment of Arbitrator Section 11, Interim measures by court and arbitrator, Section 9 and 17, Conduct of arbitral proceedings, Section 19, Form and contents of arbitral award, Section 31, Setting aside arbitral award, Section 34, Conciliation, Part 3, Section 61 to 81, Enforcement of foreign awards, Part 2, Section 44 to 60, Enforcement of international arbitration award under conventions like the New York Convention. Now, discuss the role of Lok Adalat in dispute resolution with the relevant section. Lok Adalat means People's Court, plays a vital role in India's dispute resolution system as an alternative dispute resolution mechanism. It is recognized under the Legal Services Authorities Act 1987. Lok Adalat provides a platform for amicable settlement of dispute pending in court or at pre-litigation stage without the formalities and delays of conventional litigation. Role in dispute resolution. Lok Adalat resolve civil, matrimonial, labor and compoundable criminal cases through conciliation and mutual agreement, emphasizing dialogue and compromise under the guidance of conciliators who do not act as judges. They ensure speedy, cost-effective justice by eliminating court fees and procedural complexity. The award of Lok Adalats are final, binding and enforceable as decrees of a civil code. Section 21 of the Legal Services Authority Act 1987. No appeal lies against these awards, ensuring finality through dissatisfied parties may initiate fresh litigation. Lok Adalat significantly reduce the burden on ordinary courts by settling disputes without prolonged trials and promote access to justice, especially for marginalized communities. Their jurisdictions include disputes pending in courts or pre-litigation matters except for offences not compoundable under the law under Section 1905 Legal Service Authority Act 1987. Now, question 9. Define conciliation and scope in dispute resolution, how it differs from arbitration. Conciliation is a voluntary, non-binding alternative dispute resolution process in which a neutral third party called the conciliator helps disputing parties reach a mutually acceptable settlement. The conciliator facilitates communication, identifies issues, and may propose solutions, but the ultimate decision rests with the parties. Conciliation is flexible, confidential, and focused on preventing relationship with the conciliator playing an active role in bridging the differences. A role in dispute resolution. Conciliation promotes amicable settlements without formal adjudication, saving time and cost. It is governed under Part 3, Section 61 to 81 of the Arbitration and Conciliation Act 1996, covering appointment of conciliator, principle of independence and impartiality, and the binding effect of settlement agreement post conciliation. The process enhances party autonomy, confidentiality, and fair resolution through cooperative negotiation. Now, what are the difference between conciliation and arbitration? Number one, conciliation is non-binding, but arbitration is binding. In conciliation, conciliator actively suggests solutions, but in arbitration, arbitrator delivers final enforceable award. In conciliation, parties control the outcome, decision making, whereas in arbitration, arbitrator decides and issues the award. Conciliation is informal and flexible procedure, whereas arbitration is formal and procedural rules apply. In conciliation, settlement agreement is binding only if parties accept, whereas in arbitration award, it is legally binding and enforceable as a court's decree. Thanks for watching this video, friends. Do subscribe this channel.